Good morning. In today's class, we are going to study about payment of checks. In the previous classes, you might have studied about what is a check and what are the various characteristics or features that a check should possess. Now, how banker has to take care when he is paying, when he received a check. Now, under this title, we are going to study the introduction part, paying banker, legal position and statutory obligation of paying banker, precautions to be taken by paying banker, banker's position in material alterations, statutory protection to the paying banker, payment in due course, refusal of payment and dishonor of checks. Now, a banker receives deposits from customers. He is under legal obligation to honor checks issued by the customer. Now, the very function of a banker is to accept deposits for the purpose of lending loans. So, it doesn't mean that banker can refuse making payment to the customers when the customer is asking or demanding for the payment. Whenever we are reading about the payment of checks, payment for the checks, it is on demand. So, customer has all the rights to withdraw whenever he wants any amount. So, a banker receives deposits from the customer and he is under legal obligation to honor checks. Now, when we are understanding this honoring of checks, we have to understand that the banker has to make a payment whenever he is demanded or whenever the customer is demanding for payment. Money deposited always belongs to customers. This we should remember. So, the customer is depositing money and that money is always belonging to the customer, and the bank is bound to return its equivalent amount to the customers or to any person to his order on demand. Now, Section 31 of Negotiable Instruments Act of 1885 states that the drawee of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such check must pay the check when duly required to do so, and in default of such payment must compensate the drawer for any loss or damage caused by such default. Here we are observing two terms. One is drawee, the other one is drawer. Drawee is the drawer's banker. Drawee is the drawer's banker. Now, drawer is giving a check. When the drawer's account is having sufficient funds and the check is properly made and the check has come for the payment or payment of such check, must pay the check when duly required to do so. What happens if the person or if the banker is refusing to make the payment? See, for any inconvenience caused by the banker for not payment of checks, must compensate the drawer for any loss or damage caused by such default. Now, we have to understand here that the banker is bound to make payment when sufficient funds are there in the drawer's account and the check is properly made. Now, circumstances under which the paying banker bound to honor checks of the customer. So, when banker it is his obligation or it is his duty to make payment for the checks. Now, under which circumstances a banker has to pay the payment or has to make the payment. Now, see, here we are having the list of circumstances or the conditions under which it is an obligation or banker is bound to make the payment. He shall honor his customers' checks to the extent of funds available and in the absence of any legal bar to such payment. Now, when sufficient funds are there and the banker is bound to make payment, well, because funds are available and there is no legal obligation or legal bar for not making any payment. The instrument should be in writing. Here the instrument refers to the check. Now, when you are issuing a check, in writing we are issuing the check. The check must be unconditional order to make the payment. Now, the payee must be certain person or persons. It could be a person, or it could be the group of individuals, or any association, or a corporation, or any company. The check should bear the signature of the drawer. This is mandatory and this is compulsory. The drawer has to put his signature, he has to sign if a check has to be honored. It should be payable to bearer or order. Now, bearer is a person who carries the check, and it is over the counter payment can be made, and sometimes it can be a crossed check. Now, crossing of checks, you have studied in previous classes. The two transverse lines in the left hand top side of the check we call crossing of check. When it is crossed, the check is crossed, the payment has to be made from account to account, not over the counter. Now, in both the cases, the payment has to be made. It should be payable to bearer or order. Now, since a check is payable on demand, there shall be a demand made to the banker for its payment. So, the drawer has to make a demand, or on the check also, if you see, it will be mentioned as a demand from the drawer's side to make the payment. The check must be in order in all respects and must be duly present for the payment at the branch where the account is kept. Now, previously, you can visit a branch, or you can visit the bank where you have account only. Now, all bankers are accepting payment or receiving deposits also in all other branches too. Not necessary that you have to approach only the branch where you have account. But the condition here is you should have sufficient funds. Then you can present your check for the payment at the branch. Now, precautions to be taken by a paying banker while honoring checks. What precautions banker has to take into consideration, or what precautions banker should follow while honoring checks, if at all banker has to make the payment for a check. Now, first he has to look into the form of the check. Now, every banker will have their own format of a check, a prescribed form. It is not that as and when you can feel like giving a check you are giving. No, it has to be in the prescribed format issued by the banker. The format is designed by the banker and issued. The checks are issued by the banker, and those checks only drawer has to use, and it is bound duty of the banker to see whether it is in the form of the issued check or not. Next, open or crossed check. Again, open check is without crossing of check. Now, any person who bears the check, who carries the check, now can take over the counter payment for an open check. Now, crossed check is from account to account only. In certain cases, there is prescribed bank where you can deposit this check. Only in that bank only you can collect money from that bank account. So, in both the cases, either it is open or crossed check, banker has to verify. Now, date of the check, it is mandatory that the date of the check should carry the date on which day it is drawn. Now, here the date of the check is mandatory because compulsory, because some banks are accepting checks for the payment within 3 months, and some banks are accepting to make a payment within 6 months. But in this we can know only when the date of the check is mentioned. Now, amount of the check, banker has to verify whether the amount that is written in number and in words both are same or not, properly written and properly mentioned on the check. Both the amount which is written in the number and also in the description in writing also, the amount should be same. Funds of the customer, banker has to check whether there are sufficient funds. Insufficient funds or inadequacy of funds lead to dishonoring of the check. So, banker has to be careful before making payment. Now, precaution regarding material alterations. This material alteration also you must have studied in previous classes. Material alteration is any changes that are made once the check is drawn for any other reason. If the check on the details of on the check are overwritten or some alterations, changes are made, it is the banker's bound duty to check whether any alterations are made, and if alterations are made, he has to take confirmation from the drawer. So that is the reason whenever there is a change, banker will ask the drawer to sign at the material alterations that he has made. And if the banker is not convinced with the explanation given for the material alterations, he may dishonor the check as well. Now, the drawer's signature is must on the check. Now, whoever is issuing the check, he has to sign on that. And then here, mutilated check. Mutilated check is torn check. In the simple words, it is torn check. When a check is torn into pieces, now it is whether banker is bound to accept that check, make payment for that check is also, and all other respects. If the banker is convinced with the reasons and explanations given for that mutilation, then banker can make payment. If banker is not convinced or not accepting the explanation or the reasons given, he may refuse to make payment. Now, it has to be during the banking hours only. So, whenever a check has come for presentation and for the making payment, banker cannot make any payment beyond the banking hours. Now, we are not talking about online transfers. Here we are talking about physical, offline visiting hours of the bank. Now, the branch and the balance available also is important. Now, these days, as I said earlier, these days any branch of your bank is accepting the check for the payment provided you visit the banker within the banking hours, and there are sufficient funds and the check is in proper condition. Now, security of endorsement. Banker also has to accept endorsement. Now, banker's duty is to check whether the endorsement is properly done and is it authenticated or not. Now, in all material alterations must be confirmed by the drawer. As I said before also, you have to take, as a banker has to take care of all material alterations and has to take confirmation from the drawer whether it is done by him or not, or he has to be taking confirmation by the drawer in the form of signatures. Now, what statutory protection to a paying banker is available under Negotiable Instruments Act? Now, statutory protection to a paying banker under Negotiable Instrument Act. Now, if you see here, the statutory protection is in case of open instruments, in case of crossed instruments, in case of material altered instruments. Now, in case of open instruments, as I said, it is an open instrument. So, nothing, the payee's name is not mentioned, or even if it is mentioned also, it is bearer check or over the counter payment can be made. In that case, in case of open instruments, the statutory protection that is available to the banker in case of bearer instruments, in case of order instruments, where the endorsement, see, where in case of order instruments, it is where the endorsement is forged or unauthorized, or where the endorsement is irregular or absent. So, here we will understand this in detail. The paying banker shall ensure that the check which is presented for the payment is in order in all respects before making the payment. Now, section 126, 127 and 129 of the Negotiable Instrument Act lays down the duties of paying banker as regards to crossed check. Now, what is the protection that it is available in case of open instrument? Open instrument is one which is not crossed. Simple. We have to understand it. It is not a crossed instrument, crossed check. As I said earlier, crossing is drawing two transverse lines in the left hand side top corner of a check. It indicates that the amount cannot be paid over the counter. Over the counter payment cannot happen. It has to be paid from account to account. Okay. Open instrument is one which is not crossed. The protection given to the banker may be divided here under two categories. One is protection in case of bearer instrument, protection in case of order instrument. In case of bearer instrument, see, section 82C of Negotiable Instrument Act protects the banker in case of checks by payable to bearer or in endorsement in bank, provided the payment is made in due course. We have to understand this. So, in all material aspects, the check is in proper form and the date is also mentioned, signature is mentioned, and it is intact. It is following all the norms. Then check can be paid. So, in that case, when the check payment is made, banker has the protection under 82C, 82 subsection C of Negotiable Instrument Act. Now, in case of order instrument, order checks can also be transferred by endorsement. The banker has therefore to verify every time the signature of the endorser. Now, see, banker will have his customers' signatures, but not whoever visits the bank. So, in that case, there are all possibilities that there can be forged endorsement. In case of forged endorsement, in case of bearer checks purposed to have been endorsed, also banker will have the protection. Now, bank protection in case of crossed checks. In case of crossed checks also, he gets protection provided he makes a payment in due course. Cross check with drawer's forged signature, in that case banker will have all the rights to refuse it, and if the banker is refusing to make a payment, then banker will have the protection. And by mistake, if the endorsement is not done properly and the cross check with drawer's forced signature is happened, then also banker will have the protection. Now, protection in case of materially altered instrument. Section 89 of Negotiable Instrument Acts protects the paying banker when he pays the amount over a materially altered checks. His interest will be protected under following conditions. When the interest, the banker can be protected when the material alterations is not apparent or it is not significantly seen on the check, then banker can be protected. When the banker has made the payment in due course, and where the check is in electronic image of a truncated check or electronic image is transferred, and when it is shared from banker to the banker, and in that case also the banker will have a protection. However, where the instrument is altered or not is a question of law to be decided by the court depending upon the circumstances of each case. Now, here we have to understand banker also, when he has taken all precautions before making the payment, now he will have protection through Negotiable Instrument Act 2. Now, payment in due course, as I said earlier, now try to understand what is payment in due course. Payment in due course is the paying banker can claim protection only if the payment constitutes payment in due course. What is payment in due course? Payment in due course means payment in accordance with the apparent tenor of the instrument. Here instrument refers to your check. Apparent tenor of the instrument in good faith. See what all the points we are covering: good faith and without negligence to any person in possession thereof under circumstances which do not receive payment of the amount there it is mentioned. Now, when the customer is given a check, banker receives a check in good faith and with all precautions, banker has made the payment in the according to the norms that have to be followed, precautions that have to be taken without any negligence, then banker can be protected, and that we call payment in due course. Now, what are the essentials of payment in due course? Payment according to the apparent tenor of the check, and it is in good faith and without negligence. Payment must have been made in ordinary course of business. Ordinary course of business is within the banking hours. It has to be presented and it has to be made payment. Now, when banker dishonors or when banker can refuse making payment. where the balance to the credit of customer is insufficient to meet the check, when the funds are not properly applicable to the payment of a check, and countermanding of payment, defect in the title of the person presenting, notice of customer's death, insolvency of customer of winding of a company, insanity of a customer, garnishee or other order given against payment, notice of assignment of credit balance, knowledge of breach of trust. See, in all these circumstances, banker will have a right to dishonor check. In all this, if you observe, if there is a defect in the title and if there is a notice that a customer is here, the customer notice of the customer's death is intimated to the banker, and then banker can dishonor the check. If it is not intimated to the banker and banker has made the payment, then banker will have protection. Now, insolvency of customer of winding of the company is informed to the banker, intimated to the banker, then banker has right will dishonor the check. Then insanity, not having sound mind. Insanity is not having sound mind. In that case also banker will dishonor the check. Then in case of garnishee or any other order that is issued by the court of law, then to not making the payment on behalf of the customer, then banker will dishonor the check. Notice of assignment of credit balance and knowledge of breach of trust, and when banker knows or come to know about the breach of trust made by the customer, in that case also banker can refuse payments, dishonor the payments. Now, let us understand when a banker has a right to dishonor of checks. Now, what is dishonoring? Honoring is making payment. Now, in all respects, banker will take precautions to make the payment. Now, banker also has certain rights. When can he dishonor? Not making payment is dishonor. Refuse to make the payment is dishonoring of check. In what circumstances? Where the balance to the credit of the customer is insufficient to meet the check. If you remember, when we have explained about the precautions a banker has to take, first thing is he has to check whether sufficient balance is there in the customer's account or not. Now, when there is insufficient balance, now balance has to be sufficient, including the amount that banker expects to keep it as the balance in the minimum balance in the account. Now, when the banker looks into the credit of the customer and finds that the amount is insufficient, the balance that is available in the customer's account is insufficient, banker dishonors the check. Banker has right to dishonor the check, and dishonoring of the check also banker has to intimate to the customer, because that the check is dishonored. Now, usually in these cases the customer has to make or payment to the when he has drawn the check on draws to the customer or to the payee, he has to make the payment to the payee within 15 days. That is what the law says. Now, in that case, banker will intimate about the dishonoring of the check along with the reason why it is dishonored. Now, when the funds are not properly applicable to the payment of the checks. Now, in this case, I will explain you this. Now, suppose there is a proprietorship and he has a current account. When there is a current account, you cannot withdraw amount like in a savings bank account. Now, if the proprietor gives a check to any other person for a current account to draw money from the current account, he has to give the reason. He has to give the reason why, or he has to mention in the back leaf, we call it a leaf of a checkbook. One check is a leaf of a checkbook. Now, back side of the check, he has to write why he is withdrawing the amount, whether it is administration expenses, whether it is any other expenditure which belongs to the business. When the funds are not properly applicable to the payment of a check. Now, for any other personal reason, a person cannot, if it is a trust, the proper reason has to be, or it has to be withdrawn only for a mentioned purpose. Now, countermanding of the payment. Suppose if I have given a check to a person and later I want banker not to make the payment for that particular check or particular customer, then I will give it in writing to the banker for stop payment and with the reason. Okay, when we have given that stop payment instruction, we call it countermanding given by the drawer. Now, in that case, banker will dishonor the check. Now, when any other countermanding is received by the banker towards the payment of check, banker will dishonor the check. Next, defect in the title of the person presenting. Suppose if I have to give a check, I have to mention the clear title or the bearer, whoever is the person to whom the amount has to be paid. Now, if it is a crossed check or if it is a bearer check, also you have to mention clearly the title of the person to whom the payment has to be made. In that case, banker, if he finds the defect in title, now I will give you one example. Now, if I have to make a payment to the college, now I have to write the college name, not the full address of the college. If I write the full address of the college on the check, now it is not valid. Banker refuses, even if it is demand draft also, banker refuses to make payment. You have to write only the title to whom the amount or money has to be transferred or made the payment. Notice of customer's death. In case customer deceased person's intimation has reached the banker, banker has right to dishonor the check. As in this case, banker's interest is protected when the customer's death information is not reached to the banker. In other words, banker is not intimated about the customer's death. In that case, making payment can be protected. But in all other aspects, when customer's death is intimated to the banker can refuse making payment, can dishonor the check. Insolvency of a customer, of winding up of a company. Now, when the customer is insolvent, we all know insolvency is inability to make the payment to our creditors. Now, in that case, banker can refuse the payment or dishonor the check. Insolvency is intimated, and along with the winding up of the company's information is intimated to the banker can dishonor the check. Now, insanity of a customer. Insanity means mental or inability or not having sound mind. Not having sound mind we call insanity. And person who is insane, if he signs on any document, not only check, on any document, that is invalid. It is the contract that is entered by any between two persons and one of them is insane. That contract is a void contract, cannot be implemented. Now, likewise, even for the payment of check also, if it is proved that the person is insane, banker can dishonor the check. Now, any other garnishee or any other order issued by the banker, by the court of law for not making payment for that customer, then banker refuses to make the payment. Now, notice of assignment of credit balance, when the funds are not sufficient and when it is intimated to the banker, and then banker can dishonor the check. Now, knowledge of breach of trust, and when the drawer signs, in this case especially the endorsement, in the case of endorsement, we see that endorsement, the person who has endorsed the check is found to have breach of trust. It is observed, it is noticed and it is proved, then banker will have all the rights to dishonor the check. Now, in this class we understood when bank can make payment, in what precautions banker has to take, and when banker can dishonor the check, refuse to make the payment, and all the statutory protection that the banker is having. Now, I hope this lesson is made you to understand the payment of checks.